Alright, sorry about that, we had an interruption in our internet here at the courthouse. Alright, go ahead and put some there.
Yes, sir.
Case number 22 CR 46, State of Ohio versus Brock Nicholas Vernon. And you're Brock Nicholas Vernon, appearing there from the jail.
Yes, Your Honor.
Alright, this is a pre-trial hearing is being conducted by Zoom. Mr. Vernon is present from the jail. His attorney, William Martin Travis, is present from his office and also from the prosecutor's office, Mr. King. Defendant's charged with escape and assault on a peace officer. Legal trial set for the 14th. This is the final pre-trial. Where we stand in this case, counsel? All right, so Mr. Vernon, you understand that if we continue this case, it will extend your speaking trial time. We have it right now. We tried within 90 days of your arrest. If you're being held in custody on this case alone, I think we are. I think. Are you being held on anything else?
Yeah.
Okay. And so if we continue the trial date, give you and your attorney more time to consider your options and set the trial back date, back a couple, 3 or 4 weeks, that will extend the speedy trial time. Possibly beyond the 90 days. There have been other things that happened in the case that probably hold it, which means stops it running while things are open, like discovery or motions. But if you're in agreement with this, I'll go ahead and grant this because I did have this set pretty quickly. I arranged you in March, and I had to, as I recall, I had to get this thing set pretty quickly because we could try. So are you in agreement with that, Mr. Vernon?
Yes, Your Honor.
You are waiving your speedy trial, right?
Yes, Your Honor.
All right, thank you. All right, go ahead. Oh, was he got a holder on him for that? Okay, all right. All right, then the court will grant a continuance. I'll reset this for pre-trial on April 20th. At 1 p.m. by Zoom. Trial date will be May the 9th at 8 a.m. And the time charged at 10% section 45.72H revised code in addition and dependent wage amount. All right, anything else we need to discuss, gentlemen? All right, thank you. We're going to go ahead and do Ms. Pitcher here next, and then we have the other 2 cases for Ms. Barker, our president here in court, Mr. Yes. Now you're going to help him out. It's all right, we're now in the breakout session on record. Case number 22 CR 93, State of Ohio versus Tanga G. Pitzer. Was set today for a bond review. Bond is setting around $25,000. All right, Mr. Underground.
Yes.
All right, Mr. King.
Thank you, Your Honor. Given the defendant is facing multiple trafficking charges, both of which is a first-degree felony, carries mandatory prison time if convicted of the state arrest involving bank place.
You've never been convicted of a felony, Ms. Pitcher? Okay. All right, court will modify the bond to $10,000 plus your OR, and the $171 deposit. And if you make bond, will be under pretrial supervision of plain custody, and you'll report to the probation department immediately upon your release. You'll be under house arrest at that residence that you just gave us, or that your attorney just gave us, Deer Run Road. All right, thank you. All right, I think that's all of the, and is the deputy back in the room there? No, not yet. Oh, okay. We're going to do a rating on Miss Malik Robinson about 1:45 by video. All right, thank you. All right, Mr. Sparks, you want to come on up and have a seat as soon as the prosecutor gets here, we'll do your case. And let's see, who's Mr., are you Mr. McKenzie's attorney as well?
Kinzer, Sparks, and Robinson.
Right. Too bad I didn't see his case with us now.
Danielle Witts, McKenzie's.
Danielle. Yeah, okay. Oh, she asked for continuance on him. Oh, for the 21st, okay. Not for today. Did you get your copy of the pre-trial?
Yes, no. Thanks. It's not today, but we were supposed to call yesterday. I don't think he did. I'll deal with it.
Case number 22023, State of Ohio versus Gary S. Sparks. President of the state is Assistant Prosecutor Attorney King. Present on behalf of the defendant is Attorney Sarah Barger. Gary Sparks.
Yes.
All right, Mr. Sparks entered plea of guilty to count 27, committing drug abuse, a fifth-degree felony. The matter was referred for a pre-sentence report, and I have received that and reviewed that. Have each of the attorneys had an opportunity to review summary?
Say yes.
Yes, Your Honor.
All right, Mr. King, anything from the state?
All those in favor, say aye, Your Honor.
All right, Ms. Barger?
I would echo what Mr. King has indicated, just within the plea agreement, Your Honor.
All right, Mr. Sparks, anything you'd like to say? Well, I'll have to say that I'm pleasantly surprised that you're here this afternoon, Mr. Sparks. I understand you showed up at probation at 8 o'clock this morning. before we got the court date was 8, and went to the probation part stuff here. So, in any event, I have been notified that, and they swabbed you this morning, and you tested positive for amphetamines and methamphetamines this morning, and also on March 1st, and you were arrested on new charges in the 11th. I don't know if those were felonies or what they are, but you were released on March 25th, 1st, and you hadn't reported since that time to the probation department. And said you were scheduled for an assessment at Another Chance in Greenfield, which used to be Freehold Associates, and you didn't show up for that. You were rescheduled for yesterday. Did you go yesterday? Okay, I didn't think so. So you're not building a real good foundation here, Mr. Parks, for to be successful on probation or community control. This is your first felony offense, and based on that, I'm going to go ahead and grant you community control. So it's a order of the court that you be placed under community control supervision for a period of 3 years under these conditions. You must obey all laws of all jurisdictions, conduct yourself in law, body, manner at all times. You must report when and as directed. Be truthful in all statements you make to the probation department, as well as any answers you give them when they ask you questions about your supervision conditions. You must keep them informed of your residence and place of employment at all times, and not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. And not enter upon the grounds of any local or federal or state correctional facility of any type, nor may you communicate or attempt to communicate with anyone as an inmate in those facilities without prior permission. Now, because of this conviction, you're prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any kind of a firearm, ammunition, dangerous ordnance. And you're not permitted to have any of those or any other weapons while you're under probation or community control. You're not permitted to purchase, possess, or have, or use under your control any kind of a controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has an effect similar to a controlled substance or drug abuse, nor any instrument, device, or thing that may be used to administer those or prevent administration or use unless you have a proper legal prescription, and you must provide a copy of that within 24 hours of receipt to the probation department. You will submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, nor may be present places to be sold or being consumed even as otherwise lawful. You're not to associate with anyone as a co-defendant in this case. Exception would be your wife. Was your wife a co-defendant in this case?
Yes.
Yeah, she was. All right. So that's an exception. But other than that, you're not to associate with anyone who's an inmate. Who's a co-defendant or has a criminal record, a member of a gang, or any person who has in the past or could in the future influence you to commit a violation of these conditions or a new criminal offense. You are to report any contact with law enforcement on your arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Provide your supervising officer financial information records so your ability to pay any fines, fees, or costs will be reviewed. You're referred for an evaluation or assessment for any kind of treatment, therapy, training, counseling of any kind. You're to submit to that. If you are recommended to have programming, you must enroll in and successfully complete that. You're to pay the court costs of this action and make payment arrangements with the clerk to do that. You're going to be required to successfully complete residential program, and I believe they have a bed available for you at Massey House next week. So you can successfully complete the substance use disorder residential treatment plan and aftercare. Now, by being placed in community control rather than be sentenced to prison, you're being consented to serve without a warrant of your person, residence, vehicles owned by you, used by you, or any other property placed under your control where you're found at any time, any officer of the probation department. There'll be no fine, there'll be no driving suspension. You're also ordered to pay the court cost as a subsequent order. If you don't make payment arrangements and don't pay your costs, and the court order you do service, give you credit for each hour work and an hourly rate set by the court authority, try to work with the judge by that until paid full. Now, any event probation feels you fail to comply, they will file a written notice of that to the court, serve a copy on you, and we'll have a hearing. The entitled to be represented by an attorney. The outcome of that hearing is you fail to comply, then the court will revoke community control, sentence you to a prison term between 6 to 12 months, fine you $2,500. If that occurs, once you serve the prison term imposed by the court, the parole authority may, as part of the sentence, put you into what's called close release control, which means you'll be supervised by a parole officer on the terms they set for a period of up to 2 years. If during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to 6 months for one or more violations. However, if you are convicted of a new felony, then an additional whatever sentence the judge in any case imposed upon you, that judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time that on that period of close release control occurs. If that occurs, that must be served consecutively to sentence in a new case. All right, now, since you're obviously under the influence, I can just tell by watching you that you're fidgeting and carrying on, and you tested positive this morning and indicated in the report that you were acting erratically. For your own safety and make sure that you don't commit any other offenses, you're going to be remanded to custody. Sheriff, now you'll remain in custody until you're taken to the residential facility next week. I forget that date. I'm thinking it might be the 13th. But
It's the 13th, Your Honor.
13th, all right. So you'll remain in custody until you're conveyed to Massey House. All right. Is there anything further for counsel?
No, Your Honor.
All right. You're remanded in custody there, Mr. Parks. Solana Kinzer. You may. Did you switch this over, Ben?
Yes, sir.
Okay. All right, this is case number 21 CR 202, State of Ohio, which is Solana Kinzer. Kinzer is present for counsel, Sarah Barber, present on behalf of the state, is Assistant Prosecutor King. The defendant is filing a motion for intervention in lieu of conviction. She is charged with breaking, entering, and theft. The court has received the report indicated that she had been in treatment through counseling center, just completed residential treatment. I understand she's now in the transitional housing program. Is that correct?
Yes.
Okay. All right. So the court's been presented then with a plea of guilty form that indicates, Mr. Kinzer, that you're going to plead guilty in exchange for the recommendation that should be put into the intervention in lieu of conviction program. Now, under the law, normally when somebody pleads guilty to an offense, they're found guilty, and then the court imposes a sentence, which could be a prison term, could be, in this case, 6 to 12 months, could be a fine of $25, could be a combination of those, or it could be community control. Community control is basically probation, and that can be for a period of up to 5 years. Now, there is a program under Ohio law that appears that you need the qualifications for, and that is if someone has committed an offense and that a major positive factor of that offense was substance use disorder, substance addiction, or alcoholism or mental health, in this case it would be substance use disorder, then when that person pleads guilty, rather than finding them guilty, the court will hold the plea in abeyance and stay the case. And what that means is the case is frozen. So even though you pled guilty, you're not found guilty. Because until the court actually finds you guilty and sentences you, you don't have a conviction, even though it shows you pled guilty. Then what the court does is put you into this intervention program. Now, under the law, what that means is that you have to be in a treatment program, which you are. You have to successfully complete the entire program, including its transitional housing and any other aftercare that they're recommending. And you have to comply with certain conditions of supervision through the probation department, which are less strict than if you were found guilty and put under control. Now, again, it could be up to 5 years. I put people on this program for 2 years because I think that 2 years is enough time to determine whether or not that person is serious about their recovery and is going to be successful. And one of the key requirements of that by statute is that you must refrain from using any kind of a controlled substance or drug abuse or alcohol for a period of 1 year. It's absolute. You can't use any of them. Plus, you have to be compliant with your program of treatment, and then you must comply with the conditions. Now, if you do that, then at the end of the 2 years, or sometimes earlier, if you've done extremely well, if the court is notified that you have successfully completed your treatment and complied with all the conditions, then the case will be dismissed. So even though you entered a guilty plea in the file, you've never been found guilty because the court has stayed your case. And then the court sets the matter for a sealing hearing, and usually unless that person gets arrested before that hearing, then the record is sealed and then it's removed from all the public records and law enforcement and court system. So if somebody checks, then you don't have the record. So that's the big advantage to you, is you have the ability to be able to go through your recovery and be compliant with that and have this case dismissed and the record sealed. Now, if you don't comply with your treatment program, or if you don't comply with the conditions of supervision, then the probation department files a notice of that in writing to the court and gives you a copy of your notified of your hearing date, and then there's a hearing conducted at which you will be represented by an attorney. And if you can't afford to hire one, the court will appoint for you at that time. And if the outcome of that hearing is that you have been proven by the prosecutor's office to have failed to comply, then at that time the court terminates your intervention program and then finds you guilty. But then the next step would be sentencing. And then the court, as I said, could impose a prison term of between 6 and 12 months and fine you $2,500. Or the court puts you on community control for a period of 5 years, which would start all over again. Now, if that were to occur, those conditions are much more strict and much more numerous, because now you do have a felony conviction, and the court feels that you people in that situation need more strict and intensive supervision. And then it works the same way as the intervention program. If you don't comply with the conditions, the probation department has to file a notice alleging that to the court. You are given a copy, or you have a hearing and have the right to have an attorney at that hearing. And at that time, if the outcome of the hearing is that you fail to comply, then the court could revoke your regular community control at that point, and then send you to prison with 6 to 12 months and fine you $2,500. And if that happens under the law, the adult parole authority then, once you complete the case, can put you under further supervision, what's called post-release control supervision after you finish your prison term. In this case, it's optional. They don't have to do it, but they could. If they did, it would go up to 2 years. And if they determine that you had failed to comply, then they could return you to prison, even though you served the entire term set by the court for an additional period of up to 6 months in this case for 1 or more violations. But if you committed a felony while under post-release control, then an additional whatever sentence the judge in a new case would impose upon that judge can then also sentence you to an additional period of 1 year, whatever time is left on that period of post-release control, generally greater. If that occurred, that must be served consecutively with the sentence in the new case. You understand all that?
Yes.
Okay. Now I have here your the paperwork on this. It looks like it was faxed to someone on February the 17th, 2022, and so it's a copy. But I'm looking at actually, I see that there are original signatures on here from Ms. Barker and Mr. King. And at the top of page 3, there's a sentence that says, I am this plea voluntarily, and it looks like signature of Selena Kinzer, 2/17/22. Is that the date you signed this agreement?
Yes.
And you were at the counseling center when you did that, and you back up here?
Yes.
Okay. Now, did you talk to Ms. Barber about this before you signed this agreement with your attorney? And she explained everything to you and answered all your questions?
Yes.
Did you understand that by signing this document, you are agreeing to plead guilty, meaning there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes.
Okay. So the agreement says you're going to plead guilty to count 1, breaking and entering under 2911.13a. The Higher Advice Code 853 felony. For the state, you understand the maximum prison term for this would be 12 months if 1 is imposed, and then it would be 6. It could be anything in between those two, and it would be fined up to $2,500. You understand that?
Yes.
You're not facing any felony charges other than in this case right here, right?
No.
And you are not on probation, community control, parole, or personally controlled for a felony?
No.
All right, now, the charge in this case alleges that on or about November 7th, 2021, in this county, that Samuel McKee, Brian Van Hoos Jr., Harold J. Kramer, and you did knowingly by force, stealth, or deception, trespass in an unoccupied structure to an empty house at 3853 State Route 136, Hillsborough, with purpose to commit therein a theft offense defined in ORC Section 2913.0281 or felony, in violation of Section 2911.13a of the Ohio Advisory Code, breaking and entering a fifth degree felony, which again carries a possible prison term between 6 to 12 months, fine of $2,500. All right, now, Ms. Kinzer, you understand what you're charged with and what the state says you did, when, or how they let you did it?
Yes.
You understand the possible penalties for this offense if you're convicted and sentenced?
Yes.
Now, have you discussed the nature of these charges, the evidence in the case, the possible legal issues in the case, the possible offense you might try to raise in trial with your attorney? Are you satisfied with your advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
Yes.
And are they, for any of those prescriptions you're taking, interfere with your ability to understand what's going on or to express your thoughts accurately?
No.
Do you understand everything we talked about here today?
Yes.
Okay. Have any threats been made to get you to plead guilty here today?
No.
Now, on page 2, there's 2.5 lines or so that are printed in bold and underlined and read as follows. Defendant shall plead guilty to count 1, statement dismissed count 2. State recommends intervention to a conviction. Defendant agrees to make full restitution. Defendant agrees to cooperate fully against co-defendants. That's the end of the quote. And is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Do we have an amount on restitution?
There's no restitution.
There's not. Okay. All right. Now, are there any co-defendants still cases pending? No.
Yes.
I think Mr. McKee.
He and Kramer are both still pending.
Okay. All right. So you understand you'd be required to testify truthfully if it's required in those cases?
Yes.
All right. Now, does anyone promise you anything other than that to get you to plead guilty?
No.
Now, do you hold any license or certificate from any state agency that regulates any occupational profession?
No.
And you have certain constitutional rights you should understand. The reason I explain this to you is because this is your last chance to stand on a non-guilty plea and have a trial. Because if you aren't successful in the program and the court ends up terminating you, you don't get to come back to court and start over and say, okay, well, that's what the shot, let's have a trial now. Because you're pleading guilty. And so that's why I have to explain these rights to you. So, personally, you have the right to counsel. Ms. Barber is appointed to represent you not to simply work the case out, but to provide any defense that could be available to you under the law that you would like to provide. So, if you decide that you do not want to plead guilty, that you want to defend against this case, then she'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes.
Under the Constitution, you have a right to have a jury trial in this case, Ms. Barber. Ms. Kinzer, in which 12 people will be selected from a group of citizens who live in this county that are summoned for jury duty on the trial day. Once they are selected, the evidence will be presented, and they will be instructed on the law by the judge. And then the jury of 12 persons would have to find by unanimous verdict, all 12 would have to agree as to whether or not the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. And in that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, it's the judge that hears the evidence, the judge applies the law, the judge decides whether or not the state proved your guilt, proved you unreasonable doubt. You understand that? All right, now under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them for your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence to help your side of the case. You understand that?
Yes.
And under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have any witnesses that you're not certain are going to come in voluntarily, if you request for each of the court order as a subpoena, that forces those people to come to court and be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in court and testify against you. You understand that?
Yes.
All right, now, Mrs. Kinzer, under the law, you have a privilege against self-incrimination, which means you cannot afford to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can. That is your decision. And if you decide not to testify, the fact that you did not testify not be used against you in any way by any person at any time. No one can not comment about it, except in one situation, that is if there's a jury trial and you do not testify. Judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Under the Constitution, you have a privilege against, you have a presumption of innocence. And what the presumption of innocence is, that you're presumed innocent until proven guilty by the state of Ohio on every essential element in the offense charge. Because under law, you're not required to prove that you're not guilty simply because you've been accused. In fact, in trial, you're not even required to put on any evidence to defend yourself. You may, but you're not required to. But whether you present any evidence in your defense or not in trial, the burden of proof remains on the state to prove your guilt by proving beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes.
All right, now originally you entered a plea not guilty. Not guilty plea denied the allegation in the indictment denied you committed the crime, and that plea exercised or invoked all the rights that I just described for you here this afternoon. Now, if you change your plea from not guilty to guilty, that's the opposite of not guilty plea. Guilty plea admits the allegations, admits their crime, which are the one who committed that crime, and that plea wages up all the rights I've explained to you today, except right to have an attorney. Except right to have an attorney no matter what you plead. That exception, your plea of guilty, waive or give up the right to jury or court trial, waive or give up the right to confront witness against you, cross-examine your attorney, waive or give up the right to use the power of the court to compel or force witness to be in court to testify for you, the same as the state. Waive or give up the privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty if you get to that point. And finally, well not finally, but you waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives up any right to file an appeal, which you think you may have had up to this point in the case. Now, if I were to sentence you the maximum sentence in the future under the circumstances you file an appeal will have to be filed for 30 days and your sentencing has to be filed. You understand all of that?
Yes.
You're a U.S. citizen?
Sorry?
You're a U.S. citizen?
Yes.
And you've entered into this agreement voluntarily?
Yes.
All right. Now, do you have any questions about the intervention lieu of conviction program or what's expected of you?
No.
You understand?
Yes.
Have any questions about the charge or the possible penalty?
No.
You understand that?
Yes.
Have any questions about the plea agreement?
No.
You understand that?
Yes.
Have any questions about the constitutional rights of the plaintiff?
No.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, and what the consequences of that would be if you enter here today?
No.
You understand?
Yes.
Anything you'd like to speak with Ms. Barber about before we go any further?
No.
Have any questions about anything that I've explained or talked about here today?
No.
Is it your decision then to go forward with the plea agreement and plead guilty to the charge of breaking and entering the first count, in accordance with the plea agreement that I was just kind of, is that your decision?
Yes.
All right. And as to the charge which alleged is that on or about November 7, 2021, Highland County, Ohio, that Samuel McKee, Brian Lee Van Hoos Jr., Harold J. Kramer, and Selena M. Kinzer did knowingly by force, stealth, or deception, trespassing an unoccupied structure to win an empty house at 3853 State Route 136, Hillsborough, with purpose to commit their theft offense, defined in ORC section 2913.0281, or a felony, violation of 2911.13a, the Ohio Revised Code, a felony break and entering, fifth degree, carrying possible prison term 26 to 12 months, and fine $2,500. How do you pay? Okay, thank you. You can be seated. All right, the court finds on this day, no court defendants advised of all constitutional rights may no intelligent voluntarily waive the same pursuant to Rule 11. Please, the second order filed. The second count of the indictment is dismissed. Court finds that the defendant's drug dependence was a factor leading to the criminal activity which he's been charged and admitted, and rehabilitation through continued treatment will substantially reduce the likelihood of any further criminal activity. She is currently checked in and being treated in and approved for certified treatment program at the counseling center. She's otherwise eligible for controlled sanctions as evidenced by the stipulated questions and the information in the report. She's not a repeated dangerous offender, and she's otherwise eligible under 2951.041 of the Revised Code for intervention. Therefore, the court accepts the defendant's guilty plea. However, we don't make a finding at this time. Instead, all criminal proceedings are hereby stayed. The defendant is placed under supervision of the probation department under controlled conditions adopted by the court for this program of intervention with conviction for a period of 2 years. To be required to successfully complete the intervention plan, which includes the requirement to abstain from drugs or alcohol for a period of at least 1 year. Again, the program will be 2 years. She'll be required to comply with all conditions of the probation department that I indicated earlier that the court has set for this program, and complete her intervention plan and any other treatment requirements. And if she does that, then at that time, upon notice of that, the court will dismiss the charges against her. She also will be required, as part of the conditions, to pay the court. Now, in the event that the defendant is alleged to fail to comply with either her treatment program or conditions of supervision, then the probation department will file written notice of the court. The court will conduct a hearing and will appoint counsel for you. And if you have that hearing since you failed to comply, at that time the court will terminate you from the intervention program, find you guilty. He could imprison you for a period of between 6 to 12 months and fine you up to $2,500. All right. Anything further, counsel? Now you've completed the case. You're no longer under pretrial supervision conditions, but you will need to report down to the probation department as soon as you get down here to tell them that you've been put into the end, you pled guilty and were granted intervention. And I know they're in training today, but I think they have somebody at the office who will set up an appointment for you, and you probably do it by Zoom or phone since you're down at the counseling center. We have a number of probationers in that program down there, so. They'll figure out what you need to go out probation weekly. They can later just pull that out. All right, thank you. All right, let's see if they're out there. All right, are you, Malik A. Robinson? Malik E. Robinson?
Yes, sir.
Okay. Oh, I guess I've got, okay, I'm just reading the caption of the jacket. Okay, actually, the name is in the indictment is Malik Aubrey Eugene Robinson. Is that you?
Yes, sir.
All right. This is case number 22CR057, State of Ohio versus Malik Aubrey Eugene Robinson. Mr. Robinson is appearing by video from the Justice Center. The defendant was charged on March 1st, I believe that's the date on this indictment, along with 3 co-defendants. And looks like Mr. Robinson is charged in all 10 counts in the indictment. Counts 1, 3, 5 are all trafficking, aggravated trafficking. 1 and 3 are methamphetamine with the sentence rule. 5 is a trafficking and related compound with the sentence rule. And then counts 7 and 9 are aggravated trafficking methamphetamine. And then the other counts, the odd number counts, are all aggravated possession. Now, the first count, the indictment reads that, or summarize it, is that alleged on or about March 16th of 2021 in this county, you and the co-defendants knowingly sold, rock, or sell methamphetamine, a schedule 2 reports of the same school. That is a third-degree felony which carries a possible prison term between 9 and 36 months, fine of $10,000, mandatory fine of $5,000, and license suspension of 6 months to 5 years. Count 2 alleges on the same day you knowingly obtained possession used methamphetamine. That is a fifth-degree felony which carries a possible prison term between 6 and 12 months, fine of $25,000, license suspension of 6 months to 5 years. Count 3 alleges on or about March 19th in this county, 2021 in this county, that you and co-defendants knowingly sold, rock, or sell methamphetamine again in a amount equal to or exceeding 5 times involved, less than 50 times involved, and that is done in the same school term. That is a first-degree felony which carries a possible prison term set by the judge at a minimum of 3 to 11 years. And that's mandatory time, it all has to be served. And then it could be extended by up to half by the Department of Corrections. There's a fine available of $20,000, mandatory fine of $10,000, and also a license suspension is available. Count 4 is that you possess the same methamphetamine rather than selling it on the same date. And that would be a second-degree felony, which is also a mandatory term between 2 and 8 years, with a maximum of up to an additional 1.5 set by the ERC. And again, that is a mandatory sentence, the 2 to 8 years. Count 5 is alleges that on or about March 19, 2021, that you and your co-defendants knowingly sold, rock, or sell a meth-related compound within the city of school. That is a third-degree felony. Same penalty as I explained earlier on count 1. Count 6 is aggravated possession of fentanyl-related compound that alleges that on about the same day as count 5. You knowingly obtain, possess, or use that, and that would be a third-degree felony, same penalty as count 1. No, I'm sorry, that's a fifth-degree felony. So that's a 6 to 12 months, fine, $25. Count 7 alleges that you and Mandy Young only, on or about March 21st of last year, knowingly sold, robbed, or sell methamphetamine in an amount equal to exceeding 5 times involved and less than 50 times involved in violation of trafficking statute. That is a second-degree felony, same penalties as I explained in earlier for count 4. And this case would be mandatory time. Count 8 is the aggravated possession of the same substance on the same day. And count 9 alleges that on or about March 24, 2021 in this county that you and Ms. Miller knowingly sold, robbed, and sell methamphetamine again, amount equal to exceeding 5 times involved and less than 50 times involved, and that's also another second-degree felony. All right. Now, Mr. Robinson, you're entitled to have an attorney in this case. If you don't have the funds to hire your own attorney, the court will appoint one for you. Are you asking for the court to appoint counsel?
No, sir.
You're going to hire your own attorney?
Yes, sir.
And have you talked to an attorney yet?
I'm in the process of talking to someone, sir.
Okay. But you don't have anything finalized yet?
No, sir.
All right. Well, in the absence of counsel, so that we get bail established for you, I'm going to go ahead and, enter a not guilty plea on your behalf, pending your employment with counsel. And do you have any thoughts as to when you might be able to get that, decision made, Mr. Robinson?
And then the next couple of days, sir.
All right. All right, well, I'm gonna set a bail review hearing for you, next Monday. That will be April 11th.
Can you do Monday?
11 a.m. If you have an attorney, we can't do that by Zoom. So I'm assuming you're talking to an attorney from out of town, not here local. Is that right?
Yes, sir.
Okay.
Yes, sir.
So if they're not able to make it down here, they can, we can do it by Zoom. So you can tell them the whole report, when you know who it is, so we can send them the invitation by email. That'll be the review of your bond. I'm gonna set a bond out for you so you know what it's gonna take to get you out and you can make bond over the weekend. The first free trial will be set for April 20 at 2 p.m. That'll be by Zoom. Your final free trial will be May 4 at 2 p.m. And do that with us as well. Trial by jury will be set for May 31 at 8 a.m. That'll be in person. According to what I've been given from the Ohio Court Network, you have one prior felony for aggravated robbery out of Montgomery County, is that correct? Pardon me?
Yes, sir.
Okay. Well, these are really serious charges, and a couple of them have been for a time if convicted. So the court's going to set bond in the amount of $25,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for additional felony and convicted, sentenced on that, regardless of what happens in this case. It will also be under, you'll be required to pay $171 as a deposit for statutory required service fees. Will be under pretrial supervision, probation department, 117 East Main Street. In Hillsborough, you report to them immediately upon your release. If you make mail after 4 o'clock, then you report the next business day. You'll be required to report to them once a week for 4 weeks, and after that, as they determine it, we ran drug testing when they order, by phone number for home self-employer, and no contact with any of the co-defendants in your case. By listing Pat Trell, Devontae Miller, Mandy Lynn Johnson, and James Bruckner. And if recommended by probation, to evaluate substance abuse and mental health issues, and appears indicated to enroll in and follow after attendance to this action. And what is your physical address you'd be living at if you make bond, Mr. Robinson?
1658 Mars Hill Drive.
1658
Yes, sir.
Marshfield.
Mars Hill.
How do you spell that?
MARSHILL Drive. West Carrollton.
I'm sorry, MARSHI what?
LL.
Okay.
Yes, sir.
Drive, is that Dayton?
West Carrollton, Ohio.
Westchester?
West Carrollton. West Carrollton.
You say West Carroll, isn't it?
West Carrollton?
Yes, sir.
Oh, okay.
And then, Mars Hill. Mars Hill is, I think it's separate too, like Mars Hill. You know, it's not together.
Oh, okay, okay. Oh, okay, like a dash, okay. Got Mars Hill, oh, okay, not, all right, thank you. So you'll have to be at that residence unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney or probation officer, in this or any other case, and also attend any kind of job training, educational programming, college classes, GED classes, etc. And also attend church services, other than that, you have to be there all the time. If you fail to comply, the court could revoke your bond and have you held in custody until further order. All right, so, and hopefully you'll be able to find out whether you're going to be able to employ counsel. In any event you cannot employ counsel, then you'll have to fill out that form, give you the detail about your income expenses and then corporate appointment for you if you're not able to hire an attorney. And if you get them hired by Monday, then make sure they contact the court. All right, do you have any questions?
Was you saying that's house arrest? I didn't understand.
Did I say one?
Because you said I had,
He wants to know if he's gonna be on house arrest, if he posts bond.
If you post bond of $25,000 plus an OR, you'll be under house arrest, in addition to posting your bond. It's a condition of your bond. Okay, any other questions?
no.
All right, thank you. All right, Nicholas McKenzie. All right, this is case number 22 CR 61, State of Ohio versus Nicholas R. McKenzie. President of the state's Central Prosecuting Attorney King. President on behalf of the defendant is Attorney Danielle Witt. And are you Nicholas R. McKenzie?
Yes, sir.
McKenzie is indicted on 2 counts, one of trafficking heroin and one of aggravated possession of fentanyl-related compound. This is a first pre-trial, and final pre-trial is April 21st, and trial date is 9th. Now, I believe I saw where the discovery was provided by the state, yes. And Ms. Witt, and also Will Pickers, have you provided discovery yet?
Not yet, Your Honor.
All right. Well, we do by your final pre-trial. Do you anticipate any pre-trial motions?
No, none at this time.
And has there been a written plea offer provided?
There has.
Now, I see you did have a conflict on the 21st, so it looks like assignment commissioners found April 22nd at 9 a.m. as an alternate time. I assume she did that.
Yes, Your Honor.
All right, so Mr. McKenzie, you're bail to give you an assignment notice here for the 22nd. So you're not required here on the 21st, but here on the 22nd, the next day at 9 a.m. instead of the
Okay.
All right, is there anything further from council?
Okay.
All right, thank you.
Please rise.
What just happened?
He don't have the file, so it's on my desk here.
Oh. Thanks, Ben. So, and your number
or? Yeah. Okay. Okay. All right, thanks.
I don't know if they're doing each other, because my house. Yeah. But I called mom like. Morning.
Be seated, please. Case number 22-CR69, State of Ohio versus Amber Dawn Robinson. Present for the state, Assistant Prosecuting Attorney King, defendant, Case Attorney Sarah Barber. And you are Amber Dawn Robinson. Robinson is indicted on 2 counts of committing drug abuse, both 53 felonies. This is actually a first pre-trial, final pre-trial set for the 21st of April, and the trial date is set for May the 12th. Now, I've been provided with a plea guilty form, Ms. Robinson, which indicates that you're going to withdraw your not guilty plea, plead guilty to the first count of the indictment. This is a 3-page form that has been prepared by the prosecutor's office. On page 3, there are signature lines. Almost halfway down on that last page, there's a sentence that reads, "I enter this plea voluntarily." And immediately below that appears to be the signature of A. Robinson, 3/29/22. Is that your signature I'm looking at?
Yes.
That's the date you signed this agreement?
Correct.
And you were with Miss Miss Barber when you signed it?
Yes.
Did she go over everything, explain everything to you?
Yes.
And you feel that you had enough time to fully consider the matter for making this decision?
Yes, Your Honor.
This is still what you want to do today, or a week later?
Yes, Your Honor.
And are you entering into the agreement legally voluntarily?
Yes.
All right, now, the document states on page 1 that you're going to withdraw not guilty, plead guilty to count 1, committing drug abuse under 2925.13b of the Ohio Revised Code, a 5th-degree felony. Further states that you understand that the maximum penalty for that could be 12 months in prison, the minimum would be 6 months in prison term imposed. There could be a fine of $2,500. There could also be license suspension 6 months to 5 years. You understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, control, parole, or post-release control for a felony in any jurisdiction?
No.
Now, under the law, Ms. Robinson, if you should be convicted of this offense, and if you should be sentenced to prison at any time, then once you complete that prison term, the adult parole authority under the law has the right, if they decide to exercise it, to require you to be put under post-release control supervision for a period of up to 2 years. And what that means is they'll set down the conditions of the court's not involved with that, parole officer or supervisor. And if they decide that you fail to comply with those conditions, then they have a right to return you to prison as a sanction for that, even though you've served all the time set by the judge, for an additional period of up to, in this case, 6 months for one or more violations. But if you committed a felony while under post-release control supervision, then in addition, whatever sentence the judge in the new felony case would impose, that judge would also sentence you, in this case, to an additional period, or for committing a new offense while on post-release control, in this case, to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. And if that occurred, that had to be served, that would have to be served secondly the sentence in the case. Now, do you understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose community control or non-prison sanctions, which is what most people know to be probation. And what that means is instead of going to prison, you'd be put under supervision of a probation officer on the term set by the court for a period of up to 5 years. If during the period of time that you're being supervised, the probation department felt that you're non-compliant, they would have to file a written set with the court. There would, you would get a copy, you would have a hearing, you would be entitled to be represented by an attorney at that hearing. And in the event that the court then found that you had failed to comply, then at that time, the court could sentence you to, revoke it and sentence you to a period between 6 to 12 months and fine you $2,500. Now, if that, and then after that, you would serve the sentence and be subject to post-release control on this matter. You understand that?
Yes, Your Honor.
Right now, the charge in count 1 in this case reads that on or about June 23, 2021, in County, Ohio, you did be the owner or lessee, occupant, or person who had custody, control, supervision of premises located at 7109 Wagon Wheel Trail, knowingly permit the premises of real estate to be used for the commission of felony drug offense to wit trafficking and methamphetamine by another person to wit Jake Bar Wright in violation of section 2925.13B of the Ohio Revised Code, which again is a fifth-degree felony, possible prison term 26, 12 months, fine, $2,500, any possible license suspension, 6 months to 5 years. Now, Ms. Robinson, do you understand what it is you're charged with, what the state said you did, when, where, and how they let you did it?
Yes, Your Honor.
And have you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, possible defense might try to raise a trial, possible outcome of the trial with your attorney?
Yes.
Are you satisfied with their advice and confidence in the matter?
Yes, I am.
Are you under the influence of any types of drugs, alcohol this time?
No.
Are you taking any prescription drugs?
Yes.
Does anything that you take interfere with your ability to understand or comprehend what's being said, or your reading, or anything, your ability to communicate?
No.
Now, has anyone threatened you in any way to make you plead guilty here today?
No, Your Honor.
Now, on page 2, towards the bottom, there's a couple of sentences that are printed in bold and underlined that read as follows. Defendant shall enter plea of guilty to count 1, the state will dismiss count 2, the state will not impose criminal control, defendant shall cooperate fully with the task force. That's your understanding of the agreement?
Yes, Your Honor.
Anyone promise you anything other than that that you plead guilty?
No.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that the sentence in this case, if you plead guilty, should be criminal control, that's up to the court, not to the parties. And so in the event that, once I've heard all the information presented, I decide that's not the correct sentence under the law, then I could impose a prison term. You understand that?
Yes, Your Honor.
Okay. Now, do you hold any license or certificate from any state agency or any occupation or profession?
No, Your Honor.
Right now, you have certain constitutional rights that you must understand before I can accept the plea of guilty term. First of all, you have a right to have counsel as far as the point of represents you, not simply work the case out, but to provide any defense that may be available to you under the law that you'd like to provide. So, decide you don't want to do this, that you don't want to plead guilty, that you'd rather defend this charge, then she will continue to represent you and represent you at trial if that's what you want. You understand that?
Yes, Your Honor.
Now, under the Constitution, Ms. Robinson, you have a right to have a jury trial in this matter, which means 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on your trial. After they are selected, the evidence will be presented, they will be instructed on the law, and they will decide whether or not the state will prove your guilt of the charge by a unanimous verdict. And that means all 12 will have to agree on that verdict. Now, if you didn't want to have jury trials, you don't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. And in that case, you would have what's called a court bench trial. That means it's the judge who hears the evidence instead of the jury. The judge applies the law. The judge decides whether or not the state proves your guilt by proving beyond reasonable doubt. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions, that's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes.
You speak up.
Yes, Your Honor.
Okay, thank you. Now, under the Constitution, you have a right to use the power of this court, Ms. Robinson, to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain going to commit voluntarily, to request court issues of court orders, called subpoena, that forces those witnesses to come to court, be able to testify on your behalf if you want them to, though they don't want to be. It's the same way the state's witnesses are required to come to court. You understand that?
Yes, Your Honor.
Right under the Constitution, you have a privilege against self-determination, which means you're not going to force to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, any person, at any time in the proceedings. And in fact, no one's even not talk about that, with one exception, and that is if there's a jury trial, you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Now, under the Constitution, Ms. Robinson, you have a presumption of innocence, and that means you're presumed innocent until proven guilty to the state of Ohio of every essential element of this offense. What that means is that the burden of proof is on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof remains on the state of Ohio to prove your guilt on every essential element of the offense charge. Approved beyond reasonable doubt, which is the highest burden of proof of stone under the law. You understand that?
Yes.
Now, originally entered plea not guilty, Ms. Robinson, that plea denied the allegations in the indictment that you committed the crime. It did exercise and invoke all the rights that I just described to you. If you change your plea from not guilty to guilty, then that is the complete opposite of not guilty plea. The guilty plea will admit the allegations in the indictment, admit their crime, that you committed that crime. And that plea gives up all the rights that I've just described for you, except the right to have an attorney, because you always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty waives gives up the right to use the power, or gives up your right to a jury or court trial. It waives gives up the right to be prompt witnesses against you and cross-examine for your attorney. Waives gives up the right to use the power of the court to compel or force witnesses to come in and testify on your behalf, the same as the state. Waives gives up your privilege against self-incrimination because you're saying you're guilty, that's what usually finds you guilty. Waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you the maximum sentence, or under certain circumstances, you file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge and possible penalties?
Not the same.
You understand them?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Any questions about the constitutional rights I've described?
No.
You understand those?
Yes, Your Honor.
Any questions about the plea of guilty, what it means, what happens at the end of that plea here today?
No.
You understand that?
Yes.
Is there anything you'd like to speak to Ms. Carter about before we go any further?
Not this time.
Then, do you have any questions at all about anything I've explained to you here today?
No, I don't. Not this time.
All right, then is it your decision to withdraw your non-guilty plea, plead guilty to the charge of count 1 for some term of the agreement just gone through?
Sorry.
Is it your decision to
Yes.
withdraw your
Yes, Your
non-guilty
Honor.
plea guilty to count 1?
Yes.
All right. Then as to count 1, which alleges an on or about June 23, 2021 in Highland County, Ohio, you did being the owner or lessee, occupant of person that custody, control, supervision premises located at 7109 Winding Well Trail, Hillsborough, Ohio. Knowingly permitted premises or real estate to be used for the commission of a felony drug offense, to wit trafficking in methamphetamine by another person, to wit Jake R. Wright, violation section 2925.13b, the Ohio Revised Code, felony fifth degree. Very possible prison term, 26 to 12 months, fine up to $25. Any license suspension, 6 months to 5 years. How do you plead?
Guilty.
Thank you. Be seated. Court finds on this day of court minutes provide all constitutional rights made known until the voluntary waiver, same percent of 11. Please accept the court file. Defendant is found guilty of the offense of count 1 and sent forth therein. The second count of the indictment is dismissed. Court orders that the matter be referred to probation department for pre-sentence investigation, which will include assessment of substance use, disorder treatment, and or mental health. Bond will be continued. Sentencing will be set for May the 4th. Oh, that's a Wednesday.
I'm here on the 5th.
Pardon me?
I'm here on the 5th.
Oh, you are?
Yeah, with Jared Hill and that one.
At 1, all right, so we'll go ahead and set that then. May, you say the 5th or the 4th?
5th.
5th, okay. May the 5th, at, put this one at 1:30. And you'll need to go to the probation department and let them know that you've been pleaded guilty and you need to have a PSI. Now, I also see here that you tested positive a couple of times. The last time was March 22nd, the first time was March 4th for controlled substances. So if you're not in treatment already, you need to be talking to them about what kind of treatment you might need to let it go. Because we have a positive test here for meth and amphetamine and marijuana. You do have buprenorphine, you currently have a prescription for that. And then you tested positive for gabapentin and have a prescription for that. And also you tested for THC in the same day, so it's still not permitted. So, but in any event, it appears that this meth use and if you're already on buprenorphine, then obviously you do have substance use issues. So you need to be treated already. Where is that coming from?
Yes, Rosemont Clinic and Chillicothe. He's my, family physician and my spouse doctor.
All right, well, that's not, that's a doctor that prescribes buprenorphine, but still would need to be in a substance use.
Oh, FRS, I've already been going to FRS.
You are going to-
Yeah, I've already been evaluated.
Okay, the doctor that works for them, then, okay, I got you.
Yeah, so I've been going to FRS now for the second week.
All right. Okay, so report down information as soon as, you get a signed post here from Ben. Anything from the council?
No, no, no.